Hello, everyone, and welcome to Friends Life Care's Financial Symposium and the current session titled The Impact of the Coronavirus Pandemic on Estate Planning. My name is Joe Connor, and I am the Chief Financial Officer of Friends Life Care, and I will be the moderator for this session as well as the remaining sessions that we have today. We have 3 more planned for the remainder of the day. Before we get started, I'd just like to go over some housekeeping items to ensure you know how to fully participate in today's webinar. You'll have the opportunity to submit questions or any comments at any time during the presentation by typing in the Q&A box at the bottom of your page, of your screen. The presenters will answer questions either during their presentation or at the end, depending on what the question is. I'd like to introduce our speaker for this session. Our speaker today is Nego Pile, and he is an elder law, estate, and special needs attorney. Nego assists families, seniors, and persons with special needs in the Philadelphia and New Jersey area by providing comprehensive planning, life care services, and legal representation. Nego helps seniors and their families plan for Medicaid benefits and apply for those benefits when appropriate. He advises clients on simple to complex estate planning methods, including the preparation of general trust, special needs trusts, last wills and testaments, and power of attorney and advanced directives. So, Nego, I'd like to turn it over to you.
Good morning. Thanks, Joe. And thank you for having me. For today's presentation, we're going to talk a little bit about the Secure Act and the CARES Act, focusing primarily on the retirement benefits of those particular acts. Both of those provisions, the Secure Act and the CARES Act, they have a number of provisions that would be that could literally take all day. So I wanted to just focus on one particular aspect of the of those acts that have been enacted. And we'll also talk a little bit about the estate planning and some of the estate planning objectives and goals that you'll want to do and take advantage of, as well as some estate administration benefits and looking at ways that you can reduce taxes on your estate. So we'll get started. The CARES Act. This is the Coronavirus Aid, Relief, and Economic Security Act. This was passed in March of 2020. The CARES Act provided economic assistance for small businesses and individuals. It included provisions related to retirement accounts, and we're going to talk a little bit about some of those retirement account provisions under the CARES Act. Now, the CARES Act, it's a $2.2 trillion economic stimulus into the economy, and it was in response to the COVID-19 pandemic, which we are still under. And one of the provisions under the CARES Act is that it gives breaks to coronavirus-related distributions, CRDs. So when you hear the term CRDs, we're going to be referring to the coronavirus-related distribution. The 10% tax on pre-age, meaning any distributions before 59 and a half, under the old rule, you would incur a 10% tax for those distributions. With the enactment of the CARES Act, that 10% tax and that 10% penalty was removed. So individuals before 59 and a half, if they took distributions from their retirement accounts, they could expect under the CARES Act not to incur that 10% penalty. The coronavirus-related distributions can be made from 401k plans. You can use it for hardships, any hardships that you're experiencing under the coronavirus pandemic, and that could be termination of employment, other hardships that you may encounter, financial hardships that you may encounter because of reduced hours from working, as well as any impact that would affect your earnings, meaning that your earnings would have decreased. The income tax on CRDs can be spread over 3 taxable years, as opposed to incurring the income tax, all at one point, which was previously the rule. And so you have the opportunity with those distributions to spread the income tax over a 3-year time period. Also, the individual taxpayer can roll all or part of the distribution into a qualified plan or an IRA at any time during the 3 years, starting the day after the date of distribution. These rollovers are treated as direct trustee to trustee transfers within 60 days. So the 60-day rule in terms of transferring your retirement account would apply in this particular situation, where the individual would roll part of the distribution into a qualified plan or IRA. And that would allow the individual to avoid the 12-month limit. Normally that would be applicable to rollovers between 2 IRAs. The CARES Act also increases limits and it extends repayment deadlines for loans from 401k plans. This is another added benefit under the CARES Act that individuals can take advantage of. So the CRD or related distributions, the date of the distribution and the maximum total amount, the rules.
Nego, can I interrupt you for a second?
Sure.
Your audio is a little garbled. I was wondering if you could either see where your microphone is in relation to where you're speaking and see if you can get it a little closer. We've had a few comments that your audio is a little bit garbled. So.
All right. Can you hear me all right now?
I think that's a little better. If you just sit closer, it sounds like it's working a little bit better. So I appreciate that.
Sure, no problem. All right. So the definition of the coronavirus related distribution, the maximum total amount is $100,000 per individual. And that distribution would have to be made on or after January 1st of 2020. With the new legislation that was signed in December 2020, December 27, 2020, the distributions were extended. Individuals can take a distribution for a coronavirus-related distribution up to 180 days after December 27, 2020, which extends that time period into roughly June of 2021. So individuals would be able to take a coronavirus-related distribution for up to $100,000 up to June 2021. And we'll have to see if Congress will work to extend that provision and extend it through the rest of 2021. But currently, that would be in place till roughly about June of this year. The following applied in connection with the 2016-2017 disaster distribution. The IRS allowed the individual to choose by any reasonable method which distribution would be the disaster distribution. For instance, the individual would be able to identify loss of employment. They would be able to look at the impact on paying their mortgage or paying their rent, and those specific distributions would fall under those categories for disaster relief. And the distribution would have been able to be taken at any point in 2020 and extended through June of 2021.
Nego, a quick question in this regard. So these distributions, it was back on that slide. The $100,000, there would be no 10% penalty, even if you were under 59 and a half.
That's correct, Joe.
And then would it be would the $100,000 be taxable as if it was income to you if you did not replace it in an IRA type instrument in that time frame, or is this not taxable at all?
So if you didn't replace it into an IRA, it would be taxable, but you would have the option of spreading that tax over a 3-year time period.
That was okay. And you had mentioned that in the previous. Okay, so no penalty and could be taxed spread over 3 years. Okay.
Right, and you would have the option of transferring it into another IRA, and you would have that 60-day time period within which to do that.
So you only have 60 days to put it somewhere else. If you exceed the 60 days, it's taxable. It's just a matter of how you pay the tax.
Right, and you would spread that tax over a 3-year time period. That's correct.
Yeah, I think the big benefit here is that you don't get hit with the penalty if you're under 59 and a half.
That's right. That's the major benefit. The removal of the 10% penalty for removing that distribution prior to your 59 and a half birthday.
Okay. Thank you.
No problem. In order to have the distribution treated as a coronavirus-related distribution, the individual will have to fall into a number of different categories. For instance, the individual could be diagnosed with a COVID-19, or his or her spouse or dependent could be diagnosed with COVID-19 as well. The individual would identify that they are experiencing adverse financial consequences as a result of their COVID-19 diagnosis by being quarantined, and may have resulted in them being furloughed or loss of employment or decreased hours at their job, or being unable to work because of their diagnosis and the effects of COVID-19. Also, if the employer closes or reduces the hours of their business, this could also be a financial impact that they could point to as being a consequence of their COVID diagnosis or exposure. And this would enable them to use the COVID-related distribution for getting money out of their retirement account, especially if they're under 59 and a half. And there are some other factors that the Secretary of the Treasury have expanded to allow individuals to be able to fall into this COVID-related distribution exception for seeking distributions prior to 59 and a half. So I want to talk a little bit about the Secure Act. The Secure Act is the full name of the Secure Act is Setting Every Community Up for Retirement Enhancement. This was signed into law in 2019 by President Trump, December 20th of 2019. And it modifies the rules related to the timing of distributions from retirement accounts, as well as after the death of the IRA owner. The Secure Act changed a lot of the popular retirement planning that people used in the past. The major retirement, this was one of the first major retirement-related legislation since 2006, when the Pension Protection Act was put into place. The changes that happened to the required minimum distribution rules includes raising the minimum age for required minimum distributions from 70.5 to 72 years. And so individuals would not be required to take their RMDs at 70.5. They can now take it at 72 years old. Participants in 401k and other defined contribution plans can delay taking the required minimum distributions until they're 72. Under the Secure Act, parents can also withdraw up to $5,000 from their 401k or similar workplace retirement plans. And this would allow them to apply those savings to their child without incurring a 10% penalty for taking an early distribution. The Secure Act also allows workers to contribute to their IRAs after turning 70.5. Participants are permitted to continue contributing to traditional IRAs even after turning 70.5 years old. And prior to the Secure Act, individuals were not allowed to do this. So it allows individuals to put more money into their retirement accounts at a later age, especially if individuals are working at a later age. The Secure Act also permits graduate students to treat stipends and non-tuition fellowships, the payments that they receive for those types of jobs, as compensation for contributing to the IRAs. The Secure Act also allows individuals to use their 529 plan money to repay student loans. This is a new provision that previously 529 accounts were typically for paying for college, paying for secondary education, and now you can use up to $10,000 to pay off student loans. They also extended payments for apprenticeship. So if someone was taking an apprenticeship and they wanted to take up to $10,000 to pay off the cost for that apprenticeship, they would be able to do that under the Secure Act. The Secure Act also eliminated the stretch IRA by requiring non-spouse beneficiaries or designated beneficiaries of inherited IRAs to withdraw and pay taxes on all distributions from their inherited accounts within 10 years. So prior to this provision, beneficiaries of IRAs that were put into a trust would have to use the age of the oldest beneficiary to take that distribution if they wanted to stretch it over the lifetime of the individual. And that would be the individual that was the oldest beneficiary. Now for individuals who are not spouse or spouses of the decedent or a designated beneficiary has the opportunity or they're required rather to take that distribution over a 10-year period. So the elimination of using the oldest beneficiary life expectancy has been removed, but this is only for designated beneficiaries. The Secure Act also made it easier for 401k plan administrators to offer annuities. Employees who purchase an annuity in their 401k can move that annuity to another 401k plan at a different employer or to an IRA without paying surrender charges or other penalties. So there hasn't been any change to the definition of a designated beneficiary under the Secure Act. The Secure Act for beneficiaries created three classes of beneficiaries. They're eligible designated beneficiaries and designated beneficiaries and not designated beneficiaries. The eligible designated beneficiary includes the decedent's spouse, a disabled or chronically ill child, an individual who is not more than 10 years younger than the IRA owner, a child of the IRA owner who has not reached the age of majority or 18, and additional trusts named as IRA beneficiaries are considered to be eligible designated beneficiaries. Now, the distribution rules for eligible designated beneficiaries are different than designated beneficiaries. The eligible designated beneficiary is able to use their life expectancy to spread out the distribution. So a spouse of a decedent would be able to choose between using their own life expectancy and spreading out that distribution over that time period, or they could utilize the 10-year rule under the Secure Act. And they can look at the tax consequences to determine whether one is beneficial to them or not. And they can speak with their accountant or their estate or elder law attorney. And so that same provision would apply for chronically ill individuals who receive distributions from a decedent through a trust of their retirement accounts. And same thing with an individual who is no more than 10 years younger than the IRA owner. Now, when we look at the designated beneficiaries, these are all individuals who are not the spouse of the decedent and who do not fall into the category of the eligible designated beneficiary. The designated beneficiary is obligated to use that inherited IRA over a 10-year period. So they can't stretch that distribution longer than 10 years under the Secure Act. So that's one of the provisions that the Secure Act eliminated, the designated beneficiary using the life expectancy, their life expectancy.
Nego, quick question on that. And I apologize, Nego, if it's still hearing a little bit of a mumbled sound. So I don't, however your speaker is sitting, if you could just make sure that you're speaking directly into it. We're still hearing a little. I was going to ask a question about the designated beneficiary. You said you have to a 10-year period to with the inherited IRA. Can you do it shorter than that? Can you just take it all at once?
You can. You have the option of taking it all at once, or you can spread it out over a 10-year period. and it really comes down to looking at the tax benefits of doing one over the other. And so when someone passed away and a beneficiary is going to inherit that IRA, that beneficiary, if they fall into the category of a designated beneficiary, meaning they're not the spouse, they're not one of the disabled children, or not more than 10 years younger than the decedent, they have the option of taking that distribution all at once or spreading out over a 10-year period. The next step is for them to sit down with an accountant or a estate attorney to talk about the tax implications and see which one benefits them or not.
They would choose the best tax benefit they could find over that 1 to 10 year period. So okay.
That's right. And so, with the Secure Act, we talked a little bit about the new category of eligible designated beneficiary. So this is one of the difference, and so the Secure Act tried to keep one of the provisions, that was in place prior to the Secure Act, which was the ability for an individual to use their own life expectancy. So if someone's 50 years old, their life expectancy may be for another 27 years. Let's say that as a hypothetical. They would be able to utilize that 27-year time period as their marker for taking that distribution. So that distribution would be paid out to them over their life expectancy, which in this scenario would be 27 years. So that eligible designated beneficiary category is important from the standpoint of estate planning, as well as the administrating of one's estate. So the impact of the Secure Act, it eliminated the ability of most beneficiaries to take distributions over the beneficiary's lifetime, except for the eligible designated beneficiary. If the beneficiary is a designated beneficiary, or a conduit or accumulation trust, those distributions have to be taken within a 10-year period, either a lump sum or a 10-year period, as we just mentioned. And as I mentioned before, the eligible designated beneficiary, they can still utilize their life expectancy for the payout of that distribution. So this is a list of the eligible designated beneficiaries, as I mentioned before. It includes a spouse, minor child, disabled person, chronically ill person, and a person not more than 10 years younger than the participant. So that's the summary of the CARES Act and the Secure Act. I want to just talk a little bit about some changes you want to make to your estate plan. So understanding the new acts, the Secure Act and the CARES Act, especially as it comes to retirement planning, you'll want to look at who you leave your retirement accounts to. And for instance, if they fall into the category of a eligible designated beneficiary, you have an understanding that they can spread that distribution out over an extended period of time. If they are not, and they fall into the category of a designated beneficiary, you understand that they have a shorter period, a 10-year period within which to take those distributions. And that may result in a larger tax penalty to the individual by not having the ability to spread it out over a longer period of time. So creating your estate plan, taking those things into consideration is helpful. And so you want to be able to talk with a professional, whether that's an accountant, a state attorney, elder law attorney, to really look at your planning and evaluate what is going to make the most sense for you. You will, obviously, with estate planning, the goal is to have as little taxes taken out of your uh, assets and in your distributions to your beneficiaries. And having the ability to talk with a professional to plan that out is important. So you'll want to pull your team together, and that includes your accountant, your financial advisor, estate, elder law attorney, and even your insurance advisor. The other thing that you'll want to do, especially what we're seeing with COVID and a number of people being impacted by getting COVID or knowing people who are infected with COVID, the symptoms run a number of different gamuts. Some people are infected lightly, other people are infected significantly. And so you want to make sure that if there is a possibility that you may be exposed to COVID, that you plan for incapacity, or if you're unable to communicate your financial health wishes or to handle those affairs. You want to make sure that you have people in place to act on your behalf. So you want to make sure that you have a power of attorney in place. And you also want to, if you do have one in place, you want to make sure that you are looking at it, revising it to make sure that you have the correct people and the correct decisions outlined. And you'll also want to look at pre-planned burial arrangements, funeral arrangements. Those are things that you can do right now that would alleviate a lot of pain and difficult decision making by your family members who are left behind when you pass away. The third thing that you want to consider is to evaluate and update your insurance needs. This includes life insurance, disability insurance, health insurance. All those things are important because they can impact the individuals that you leave behind.
Nego, we have a question from the group. And the question is, what does low-cost wealth transfers mean?
Low-cost wealth transfers. So that's basically looking at transferring your assets in a way that is going to impact your estate minimally in terms of cost. So when someone passes away, they have either their estate can go through probate, which is going through in Pennsylvania, going through the Register of Wills office where you identify your assets and you go through a 9-month to 12-month process of identifying your expenses, paying your expenses of the decedent, and all of that. That process is pretty timely, time extensive, and it's also costly. So if an individual wanted to remove the probate process from their estate, they may consider things like trust. A trust is something that once it's established and you have a trustee in place, that trustee then automatically goes into action when someone passes away. And that becomes something that is less expensive than one going through the probate process of going through the Register of Wills over a 9-month time period. And then within the trust itself, you can make provisions to allow for the distribution of your assets and your property so that your estate is incurring the least amount of taxes as possible. So for instance, we talked a little bit about life insurance. So if you had life insurance and you distributed that life insurance to your children, life insurance is not going to be taxed. And so the life insurance that your children receive is not taxed. And if you are leaving a spouse behind, you may want to leave some of your other assets that are not life insurance. So your retirement accounts, your other investment holdings, bank accounts, because when you transfer assets to a spouse, it's there's no tax. It's taxed at zero. So from a planning perspective, you wouldn't flip that around. You wouldn't leave the life insurance to your spouse and leave your taxable assets to your children, because that asset that would be left to the children outside of the life insurance would be taxed at 4.5%. So that's what we talk about, low cost flow transfer. And that's an opportunity to really reduce the amount of taxes your estate is going to be exposed to.
Nego, as a follow-up to that, our last presentation was by Kathy Sikorsky, and she spent a lot of time talking about how to title the assets. So I just got a question about, you're talking about trusts. Um, are trusts in place of how to title assets, or is it in combination? I'll give you an example. One of the ways that she was talking about titling assets was joint with right of survivorship. So if you have your assets titled in joint of right of survivorship, do you need a trust on top of that or in place of that, or do they go together? How do those two vehicles or those two issues go together? The titling of the asset as well as setting up trusts.
Now, that's a great question. So when you title something, for instance, with joint rights of survivorship, joint tenants with rights of survivorship, that speaks for itself. So even if you put that property into a trust, for instance, you own real estate, two people own real estate, and they hold it as joint tenants with rights of survivorship. That real estate is going to go to that other survivor, no matter what. Even if you change who you wanted to get it in your trust, the joint tenants with rights of survivorship is going to control. And so you have to use it in conjunction with a trust if someone is electing to use a trust. And basically that means that you've got to be consistent. So if you hold something as joint tenants with rights of survivorship, you can't change that in your trust. Otherwise, it's going to be incompatible. And the one that's going to win is going to be the joint tenants with rights of survivorship. What you can do is if you own property, you own that real estate by yourself, just so that real estate isn't just sitting out there and nothing is happening when you pass away, you can leave that real estate or retitle that real estate in the name of the trust. And basically that would mean that you would change the deed, take the real estate out of your name, and the trust would then become the owner of the real estate. And by doing that, your property then is held in trust. And when you pass away, your trustee would manage that real estate. And it can be distributed to the beneficiaries, or you can treat it as a rental property. There's a lot of flexibility that you can do with that property, but you can make provisions in your trust as to how that real estate will be handled.
So would you use that vehicle if you had a married couple and one passes away and you had the joint tenant with right of survivorship? Obviously, with one of the joint tenants passing away, you only have one left. Would you then suggest putting it in a trust at that point when one spouse passes away?
It's a possibility because there's a lot of things that you can look at. That's one option, and that's the strongest option. Another option would be to put another child on title. If you have a child or a beneficiary that you want to receive that property, that person can be put on title. But that comes with its own problem.
Right, that puts it, on that one child, and that child technically doesn't have to share with the other children upon death of the parent, right? So the trust would be a better vehicle to make sure if the goal of the surviving parent is to equally distribute, then a trust would be the better vehicle, or joint with right of survivorship with all 5 kids, or however many kids there are. So there's different ways to get that done, right?
Yeah, but no, you're right on target with that, Joe, because the thing is, if you've got multiple children and you try to put all the children on that deed, it comes with its own challenges because now you're exposing that property to,
Correct.
the liabilities that those children may have or encounter, lawsuits,
Yeah,
whatever.
yeah,
But
expose them to the credit risk that any of those individuals could have, right?
that's right. That's right. So if you put it into the trust, you know that the trust is going to hold the property. And, we can talk about revocable trust versus irrevocable trust, which have different implications based on where the owner is in their life. If it's an older person and, they need to do some planning for long-term care, we may, look at an irrevocable trust as protecting that property so that it's not completely exhausted if they have to go into a nursing home, or that property doesn't have to be sold if they go into a nursing home. And if the individual is younger, we could look at a revocable trust, just to make sure that there is some continuity or continuation of ownership transfer of that property when that individual passed away without having to go through the headache of uh, who gets the property and do we sell it, do we rent it. All of that can be handled by putting it into a trust. So the recommended estate planning documents that you want to have in place are your advanced healthcare directive, which is basically your election, your decisions regarding certain medical treatments that you would or would not want if you are dying, if you have a terminal condition. And oftentimes people don't communicate what those decisions are with their family. And it's so important that when you do make your wishes, that you make it known to your family, uh, especially your advanced healthcare directives. And a number of you may have probably, if you're old enough, you might remember the Terry Schiavo case that happened in Florida. This was a case where a severely incapacitated young woman was, um, uh, she was healthy one day, had a terrible injury, and became incapacitated. And her husband, um, you know, made it or had, his decision, which was to take her off of life support after she had been on life support for over a year. And Ms. Shivo's parents had a different position. They wanted her to continue on life support. Now, Terry Shivo didn't have an advance directive that spoke to the situation, so they ended up in court, and that lasted for a number of years. Ultimately, the husband and the parents, uh, reached an agreement, and the husband decision to take Terry Shivo off of life support ended up being the prevailing decision. All of that can really be avoided by someone putting their living will in place and nominating a healthcare power of attorney to be able to make decisions for them when they are incapacitated. The other document you want to have is your financial power of attorney, which is, the document that you would allow a individual to make financial decisions for you if you become incapacitated. This individual will be able to talk with your banks, your financial institutions. If you have retirement accounts, they'll be able to talk with your uh, the company that's administering your retirement accounts. If you have a pension, same situation. And so if you don't have those things in place, there's no one really there to talk to these individuals or these companies if you become incapacitated. And then finally, you want to have your will or your trust in place so that your planning can be implemented the way that you want it to be. As we were just talking, Joe and I were just talking regarding the different ways that someone can leave property outside of a will versus inside of a will or trust rather. Having the correct documents or provisions in place means that you can reduce the amount of taxes your estate pays, as well as resolving or alleviating a lot of discord between family members if there's no clear information or designation as to who received what. And one of the things that I'll tell you is that when someone passed away, there's always going to be some level of discord. How much depends on how clear you are with your estate planning that you've done or lack of. And the individuals that don't do any estate planning are the ones that we see the families, the children, the beneficiaries often fighting when it's unnecessary. So streamlining the probate process, the important things are to look, and we talked a little bit about beneficiary designation, and I think the previous presentation that Joe mentioned talked a little bit about that. You want to look at, your retirement accounts as well, and make sure that you identify the beneficiary. Same thing with your bank account and life insurance, and you always want to make sure that the beneficiaries that you name, that you haven't just left it there for years and that person may have passed away. You always want to update it. And same situation if the individual is disabled. You want to make sure that if that individual is receiving public benefits, that you change the designation of that beneficiary from that individual to either a irrevocable trust or a special needs trust, or you leave it to another trusted individual that will provide for that disabled child or disabled beneficiary. And in this day and age, a lot of people have digital assets, so you want to make sure that your access information, your passwords, your login, that you have that available to distribute to some trusted individual who will be able to get into your accounts. Oftentimes, people on beneficiaries are unable, or executors, trustee are unable to get into the decedent's accounts because there's no record of the passwords or access information. And this creates lag time as well as difficulty in properly assessing the value of the estate. And if you have creditors that have not been paid before the person passed away, that lag time can result in claims against the estate and even litigation against the estate. So having your digital assets accessible to your beneficiaries is important. You'll also want to simplify and consolidate your financial accounts. A lot of people, I shouldn't say a lot, but a number of people have accounts at 3 or more institutions. I've had a client who had 12 different accounts, 12 different locations when they passed away. And the work to do an inventory and accounting for all those accounts is time consuming, and it costs a lot of money, it costs a lot of time. Simplify it, consolidate, have 1, maybe 2 accounts, and you make life easy for your executor, your trustee, or other fiduciaries that are helping with your estate. And most importantly, you want to have a family meeting with your family to discuss all of your planning, your children, your executor, your trustee, meet with them, let them know your decisions and make it public, because ultimately that information is invaluable and it will alleviate a lot of conflicts and disagreements.
Nego, there is a question, and it goes to I think it's a pretty broad question. So, is there a step-by-step list of critical actions to take when someone passes? Someone passes, what should I guess it depends what you have in place at that point, but is there, for somebody that's hasn't had this and needs to take care of somebody's estate, is there like a quick list you could go through of things that they should be thinking of as they deal with a passing of a loved one?
Yeah, absolutely. I actually uh, provide that to my clients, and if folks contact me, I can send that out to them. And it's basically a checklist of different steps, what happens now that someone passed away, and what has to be done. Everything from, uh, you know, filing the correct paperwork with the Register of Wills office if there's probate assets, um, to wrapping up an estate. So everything from the beginning all the way through to wrapping up the estate. So if you reach out to me, I'll send that over to you. Just reference that you were a participant in the webinar. My contact information is up on the screen. You can email me and I'll send that over to you. And I'll also um, uh, forward that over to the folks at Friends Life Care. So if you reach out to them as well, they can forward that information out to you. I haven't found one that I could say go to this particular site. That's something that I created because I've had that question from people before, so it's a common question.
Well, you have your email up there. So it was an anonymous attendee. So if whoever that was would like to get that list, Nego would be happy to send it to you. We do have another question, and that is, what access do state laws permit after someone passes with regards to digital assets like email, social media, cloud, smartphone, tablets, computers? Is there state laws that govern how those digital assets are managed after someone passes? We did have in our last presentation, Kathy Sikorsky talked about I think there was a new law passed just in the state of Pennsylvania over the last few days. And she referenced Facebook, and you could actually designate somebody to manage your Facebook account. I never knew this. After your death, you can designate another Facebook user to manage your account after your death, which was interesting to me because I have friends. It's a sad story that I have friends that look like they have a Facebook account and they've passed, and they look like they just sit there and there's really no end to that social media aspect of their life. So the broad question is there state laws that govern how you manage the digital assets of an individual that passes?
So there aren't sweeping state laws. It's because this gets into the whole privacy acts, both on the federal and state level, and so when someone has digital assets, the, the the process that you go through to contact the provider and providing them information regarding that individual, that their death certificate, if you are the executor or trustee, the copy of the trust or uh, the proper paperwork from the Register of Wills office. You could send that to the provider and ask the provider to open that individual's account and make the information available to you. And that's more a matter of the fiduciary contacting that provider, but there isn't, to my knowledge, any sweeping state law at least in Pennsylvania, that says these individuals or these providers um, have to provide this information to the individual that's requesting it, the fiduciary that's requesting it. So that can change. I know there's been a lot of talk regarding a lot of these privacy laws that, the Facebook, Twitter, LinkedIn, and some of these other online providers have. They have very broad powers and protection. And there has been some discussions in Congress on the federal level regarding limiting some of those protections and opening uh, the access to the information that these providers claim as being private. So we'll have to watch it and see what happens. But I imagine at some point a lot of those restrictions will be loosened because it's a little too tight right now in favor of these providers.
Nego, that was the last question that was posed. I want to thank you for spending this hour with us to go over these topics. I'll tell you one of the things that I'm personally taking away from this, and maybe others in the audience are in the same boat, is that I'll say over the last 5 to 10 years, I've been turning off statements so that I get everything digitally, and I have passwords saved in my computer, but my wife doesn't have access to all of these things. And if God forbid something was to happen to me, it would be very difficult for her to get access to all those things. So one of the things I plan to do right after these sessions are done today is make a list of all my passwords and sign-ons for all of our digital accounts, because it's just not something that was, I have a will, I have a trust, for kids and things like that. But it's just something that I just hadn't thought of. And this was enlightening for me just to think about that, and just one more aspect of my estate planning that I really just didn't think was a big deal. But it is, because, more and more organizations don't want to send you paper. And if you don't have the paper coming to the house, and your spouse or your partner doesn't know the assets exist or how to access them, as you said, Nego, it makes more difficult for the executor of your estate to find those assets, and more attorney's fees to get to those assets. So just something to think about, and just one thing that I'm taking away from this presentation. And again, I want to thank you for your time. I just have a little bit of I want to thank everybody for attending the seminar today. We have 3 additional seminars. The next one starts at 12:30, and it's financial planning strategies for single women. We have another one at 1:45, and that is wanted dead or alive. Do I need an elder attorney or an estate attorney? And then finally, our last presentation starts at 3:15, and that is savvy money habits. So it's just getting into good money habits of paying yourself first, and how you should be handling your money once you get it. But I want to thank everybody for attending the seminar. I hope you're able to join for several of the ones that remain today. A registration link was provided in the email that was for this presentation. You could register for those. If you haven't already, you can register for the additional seminars left today. All of the financial presentations will be posted on our website at Friends Life. All of these are being recorded, and they'll all be on our website at friendslifecare.org. Once you leave today's webinar, you'll receive a quick 5-question survey. We appreciate it if you would take a few moments to fill out that survey to provide us feedback on how to continue to improve these webinars in the future. And then finally, you'll receive an email in the next 24 hours with a link to the web page where this presentation will be hosted. Again, I want to thank you. Look forward to seeing you at some of you in our remaining seminars of the day. And I wish you a wonderful rest of your day. Thank you. Thanks again, Nego.
All right, thanks, Joe.